Friends, if you are watching this video first time, then please subscribe to this YouTube channel, press the bell icon notification button and like this video so that we can update you from time to time. Friends, in this video we are just discussing the comparison between the Bhartiya and Nagrik Suraksha Sahita 2023 and this act, if it passed by the parliament, then it become an act. So currently we have the Code of Criminal Procedure 1973, and if this act comes in the official gazette after the approval of the president, then it will become an act called the Bhartiya Nagrik Suraksha Sahita. It will replace the Code of Criminal Procedure 1973. So this Bhartiya Nagrik Suraksha Sahita is, in short, we can say is BNSS. It has 38 chapters as comparison to Code of Criminal Procedure. It has 37 chapters. So we have make an attempt to make a comparison between the two relevant provisions of this act. How much difference this current act will be if passed by the parliament. So it has 533 sections as comparison to the present existing its Code of Criminal Procedure. It has 484 sections. So it has the two schedules like the Code of Criminal Procedure. So not much difference we are going to observe that not much such differences are there if both acts, if we make a comparison between the both acts. This is a chapter 2, both are same. It says the constitution of the criminal codes and the offenses, both are same. Even that the chapter name is same. The classes of the criminal codes, section 6 says, and the Code of Criminal Procedure also says this classes of the criminal codes, trimmed territory divisions. This section, the metropolitan area, section 8 of the Code of Criminal Procedure, it is not available in the Bhartiya Nagrik Suraksha Act, Suraksha Sahita 2023. This metropolitan area, it's now been omitted there in the current act. So Code of Session will now be there at section 8. Earlier, presently it's there in section 9 Code of Session, and this section again has now been omitted. It's not been there in the Bhartiya Nagrik Suraksha Sahita. Subordination of the assistant session judge, this is not there in the new. These both sections are not available in the new act, and the Code of Judicial Magistrates is now there at section 9. Earlier, currently it's more precisely, if it says as per the today, it's called the Code of Judicial Magistrates. Is now there at section 11. So both relevant provisions, both are almost the same. Not much differences there in section 11. Special Judicial Magistrate section 13 is found there. It's not available at section 11. So local jurisdiction of judicial magistrates is as per the new act, it's been there at section 12. Earlier, currently it's available at section 14. So both acts are almost the same. So in this part 1 video, we are just discussing some relevant sections which are inserted there in the new act. The Code of Metropolitan Magistrate it's again has been removed, and Chief Metropolitan Magistrate and Chief Metropolitan Magistrate, these both sections, these titles have now been removed as in the Code of in the new act. This is Bhartiya Nagrik Suraksha Sahita. Even Special Metropolitan Magistrate, these terminologies will not be there, because not only is the word is there is the Chief Judicial Magistrate or Additional Chief Judicial Magistrate. No Metropolitan Magistrate or Chief Metropolitan Magistrates. This kind of sections have been removed there. So Executive Magistrates section 14, and now it's there at section 20. So almost all the provisions are same. So we can see 6 sections is a heading as per if we make a comparison between the public prosecutor, it will now be there at section 18. Earlier it's currently it's there in the section 14, the public prosecutor. So almost all the provisions are same. Now chapter 3 that speaks about the power of courts. Currently it also speaks about the power of the courts. And this section again, it has been replaced in the new Bhartiya Nagrik Suraksha Sahita. This section is not available. This Bhartiya jurisdiction in the case of the juveniles, and almost all sections are same. Both sections, sentence of the imprisonment of the default of the fine, both sections are same. So mode of conferring powers, section 626 earlier, currently it's there at the mode of conferring power as section 32 up to this chapter 4.3. Not much differences are there. Only 3 sections have been removed. That is Court of Metropolitan Magistrates not there as in the new act. Court Chief Metropolitan Magistrate and Additional Chief Metropolitan Magistrates again not there. Special Metropolitan Magistrates, this section has been removed. Now chapter 3rd is the power of the courts. Again in this chapter almost all the sections are the same. This section again has been removed. Jurisdiction in the cases of the juveniles, and sentences of imprisonment in default of fine, sentence of the imprisonment of default of fine. Both sections are almost the same. Chapters also. Now it comes to the chapter 4, the powers of the superior officers of the police and aid to the magistrate to the police. Currently, this power of superior officers of the police, its chapter part is divided into chapter 4 is divided into 2 parts, A part and B part. Now both the parts have been merged, and now it's called it will call as the power of superior officers of the police and aid to the magistrates and the police. So previously only section part A under section has only one section, that is the power of superior officers to the police. Now it's merged there, and section 37 powers to assist the magistrate and reports. Duty of the section 34 duties of the police officers employed in connection with the affairs of the village to make a certain report. Now come to chapter 5, arrest of the person, and you can see chapter section 41A, notice of the appearance before the police officer. This section is not there, but it has been merged in section 35. So under section 35 part 3 to 5 is equivalent to the current article 41A of the CR.P.C. Let's see what section 35 subpart 3 says. And the police officer shall, in all cases where the arrest of the person is not required under subsection part 1, issuing a notices directing the persons against whom a reasonable complaint has been made, or a credible information has been received, or reasonable suspicion exists that he has committed an unlawful offence, to appear him or such other place as may be specified in the notice. So there's no need to be panic about that. The section 41A has now been removed. In fact, section 35 subpart 3 to 5, it's completely elaborative, and every portion has been covered up. So section 35 only this part says, and section 34 section 34 subpart 5. Sorry, section 35 subpart 5. And where such persons complies and continues to comply with the notice, he shall not be arrested in respect of offences referred to the notice, unless for the reasons recalled the police officer is of the opinion that he's out to be arrested. So notice of the appearance is now covered, which was covered in section 41A. It will comes under section as per the Code of Criminal Procedure. There is a section called the Notice of Appearance before the police officer, and this section has now merged under the section 35, which speaks about the when police may arrest without warrant, and section 35 parts of part 3 to subpart 5. If we see that these sections, it speaks of the notice of the appearances to the accused. The whole section is same, but the numbering has now been changed. This section 35 subpart 3 to subpart 5 is which exists, which is equivalent to the section 41A of CR.P.C. The ingredients are same. The police officer shall, in all cases where the arrest of the person is not required under subsection 1, issue a notice directing the person against whom reasonable complaint has been made, or credible information has received, or reasonable suspicions exist that he has committed a cause of offence, to appear before him or that the other places may be specified in the notice. And the way notice is issued to any person, it shall be the duty of the person to comply with the terms of the notice. And when such person complies and continues to comply with the notice, he shall not be arrested. So the whole section speaks that for the lesser offence, the police shall not arrest a person unless if the accused fails or if the suspect fails to comply their terms. If the accused or suspect complies their terms, so the person shall not be arrested by the police. So all ingredients are same, and previously in the Code of Criminal Procedure, there is a section called Control of the Districts. It's now replaced as section 37, and this designated police officer, the control rooms at the districts now becomes a designated police officer. What does this section speaks? Let's see the contents. The state government shall establish a police control room in every district and state level, designated a police officer in every district and in every police station not below the rank of assistant sub-inspector of police, who shall be responsible for maintaining the information about the name and address of the person arrested, nature of the offence, with which charge shall be promptly displayed in any manner, including a digital board in every police station and the district's headquarters. So these designated police officers means the state government have now to appoint a police officer not below the rank of the assistant sub-inspector, who shall maintain a register of the name of the address of the person arrested and the nature of the offence which they may be charged. It's promptly displayed there in their registers. The other sections are almost the same. Section 42, arrest on refusal given to give name and residence, it now comes under section 39 as per the Indian Citizens Protection Code or Bhartiya, Nagrik, Sahita, Suraksha, Sahita. So arrest by the magistrate is now comes under the section 41. So almost all except the numbering has been changed. Now it's become section 41. Previously, as per the Code of Criminal Procedure, not previously, as per the Code of Criminal Procedure, it comes under the section 44. So almost all, you can see almost all the sections are almost same. Arrest how made, it's in the Code of Criminal Procedure is 46, now becomes under, if the act is passed by both the houses, it will become section 43. Almost all the ingredients are same, all sections are same. Search of the arrested person in the Code of Criminal Procedure, it's there in the section 51. It's as per the Indian Citizen Protection Code, Bhartiya, Nagrik, it comes under section 49. Power to seize offences, powers to seize offensive weapons. So every wordings are almost same, except the numberings has been changed. So these sections 53 The examination of the accused by medical practitioner at the request of police station, at the request of the police officer. Sorry, so it comes under section 52. Examination of the person accused of rape by the medical practitioner. So previously it's there section 53. Now it's been comes under section 52. And examination of the arrested person by the medical officer 54. It's now come under 53. Identification of the person arrested section 54. It's now section 54. So numberings have been changed. Almost all the contents are same. So lastly, in the section 5, chapter 5, arrest to be made strictly according to the code. This word has been changed. This word now been replaced, and it's according to the Sahita. And now the chapter 6, processes to compel appearances. So both the chapters numberings have been changed. Both the numbers are given the numbers. Chapter 6, it's there in the Indian Citizens Protection Code, chapter 6, and the Code of Criminal Procedure is chapter is number 6. But it means both the chapters are same except the sections. Summons, form of summons is there, section 63. In the Code of Criminal Procedure, it's there at section 61. And now we shall proceed further. Warrant of arrest, both. The subpart says about the warrant of arrest, and subpart B also speaks about the warrant of arrest. So except the numberings are changed, and what I've been saying is the numbering is changed, otherwise the whole contents are almost same. Section 71, power to direct security to be taken, there is section 17 for the new act. So almost all things are same, and if you see the part C, that is the proclamation and attachment. So both sections, both codes speaks about the part C of this chapter 6, proclamation of offenders, and the proclamation of the persons absconding is there at the 82. 82 will now be changed to section 84, proclamation for persons absconding. A new section has been inserted in the Bhartiya Nagrik Suraksha Sahita, that is the identification and attachment of property of the proclaimed person. In the Code of Criminal Procedure, it's not there. This section is missing in the Code of Criminal Procedure. Let's see section 86, what this section speaks about. It speaks about identification and attachment of the property of the proclaimed person. The court may, on the written request of the police officer not below the rank of a superintendent of police or commissioner of police, initiate the process of requesting from the court or authority on the contracting state for identification and attachment of the forfeiture of the property in accordance with the procedure provided in chapter 8. So this section has now been inserted. So means the police officer will have to make a request to the court. The police officer shall not be below the rank of a superintendent of police or the commissioner of police. The court, the language says, the court may initiate the process of requesting assistance for court in the or an authority in the contracting state for identification, attachment, and the forfeiture of property. Is the court can identify or can. The court may identify, the court may attach, and court may forfeiture of the person. Property of the persons of the proclaimed person in accordance with the procedure. So almost all the sections are same except the numberings are same. Let's see about chapter 7. The new Sahita says the power to compel the production of the things, and the processes to compel the production of things, and the processes to compel the production of things. Both sections are chapter heads are same. And now let's see where is some minor differences there or not. So after 101, there was a part C there in the Code of Criminal Procedure. There is a part C, general provisions relating to the searches. This this part C title is not available. It's now been replaced, and it's not been replaced, it's not available in the code of in the Bhartiya Nagrik Suraksha Sahita. This section is not available. And introduction of the search and warrant section previously is there in section 99. As per the Bhartiya Nagrik Suraksha Sahita, it's there at 102. Miscellaneous portions. So head portions, this portion is not there. So part C now will becomes miscellaneous. In the Code of Criminal Procedure, it's there at part D. And power of the police officer to seize certain property. So both sections are same. It's in the Code of Criminal Procedure, it's there at the 102. It's there at the 106. Another new section is added there in the code of Indian Citizen Protection Code, Bhartiya Nagrik Sahita. This is the recording of search and seizures through audio video. 105 speaks about the recording of search and seizures through audio video electronic means. Section 105 says the process of conducting a search of a person or taking possession of any property, article, or things under chapter or under section 185, including preparation of the list of all things seized in the course of search and seizures and signing of such list by the witnesses, shall be recorded through any audio, video, electronic means, preferably the cell phone, and the police officer shall without delay forward such recording to the district magistrate, SD, sub-divisional magistrate, or judicial magistrate of the first class. Means this sections 105 speaks that police officer now can record the list, any property, that can make a search or taking the possession of any property, article, or thing, including the preparation of list, and seized search and seizures shall now be recorded by the police officer, preferably by cell phone, and without the police officer without delay will now forward such recording to district magistrate, SPM, or the judicial magistrate first class. The section 107 speaks this, and access, and now thereafter, and section now see 107. This section is not there in the Code of Criminal Procedure. Attachment, forfeiture, or restoration of the property. Let's see this section, what this section speaks. 107, where a police officer making an investigation has the reason to believe that any property is derived or obtained directly or indirectly as a result of the criminal activity or from the commission of offence, he may, with the approval of his superintendent of police commission, makes an application to the court or the judicial magistrate taking the cognizance, exercising jurisdiction, take cognizance of the police of the offence or commit for trial, or try the case for the attachment of such property. So, and now this section says that police officer make if the police officer has the reason to believe that this property has been derived from because of any criminal activity, then police officer, after taking the approval from the superintendent of police or commissioner of police, makes a request to the judicial magistrate for the attachment of such property. The court may exercise their jurisdiction for the attachment of the property. So, and it has part 2 also, subpart 2, and it speaks that the court or judicial magistrate have the reason to believe whether before or after taking the evidence that all or any of the properties are proceeds of the crime, the court or magistrate may issue a notice appointing the persons, calling upon him to show cause within the period of 40 days why an order of attachment shall not be made. It means the court has, while whether before or taking the evidences, If the application is made before the magistrate or the court exercises their jurisdiction and issue a show cause notice to the person concerned, and the person will have to reply within a period of 14 days of the order that why this attachment of that property shall not be made. So this is the power which has been granted to the court of under the Indian Citizens Protection Bill. And next section speaks about what the person will how the person will comply. This section, relative section, speaks about the. So it has 7 parts, subparts there, and the power to bound document produced. Both sections are same, reciprocal arrangements regarding processes. So this is what in this part we have discussed chapter 7 of the Indian Nagrik Suraksha, Indian Citizens Protection Code. Remaining, please kindly be in tune and wait for our others forthcoming videos on part 2, which will cover a large bunch of the sections, and we will make a comparison between the Indian Citizens Protection Code as well and the Code of the Criminal Procedure. Hope you have liked this video. If you have liked this video, please subscribe to this YouTube channel, press the bell icon notification button, and like this video so that we can update you from time to time. Thank you.